Hi everyone, and welcome to your lecture for assignment number 31, in which we will be talking about the question of whether the Bill of Rights, those rights found in the first 10 amendments to the Constitution, whether they apply to state and local governments the same way they apply to the federal government. So when I first introduced the Reconstruction Amendments, or the Civil War amendments to you all, the 13th, 14th, and 15th Amendment, I said that these amendments fundamentally changed the relationship between the federal government and the states. And we focused in those amendments on the powers that they gave to Congress to pass legislation, to enforce by appropriate legislation, the substantive rights that were granted in those amendments. But we also saw in these amendments that they fundamentally changed the relationship between the states and individuals, the individuals living in those states, because of the number of substantive individual rights that ultimately ended up now placing limitations on things that the states could do as well. So this is what we're going to be spending the rest of our time together this semester talking about. And we are going to start by focusing on the 14th Amendment, because most of the discussion that led to these rights arises out of the 14th Amendment. And we will primarily be focusing on the Due Process Clause of the 14th Amendment, because that is where ultimately most of this discussion ended up occurring. The 14th Amendment is arguably the most important amendment in the Constitution because, as I mentioned, the 14th Amendment ultimately ended up being the vehicle that incorporates most of the provisions found in the Bill of Rights to apply against the states. And in doing so, this fundamentally changed our collective understanding about what it is the Constitution does. This conception of the Constitution going from being primarily a document about establishing a government and separating the powers to becoming one that in most Americans' minds is a document that is the repository for our individual civil liberties. And it did this by drastically changing this relationship between individuals and the states. If you think about how often most individuals interact with the law in various ways, you might see how, even though we tend to focus on federal politics, most of our interactions actually come with the state rather than the federal government. The vast majority of the laws that apply to us that come from state or local government, things like law enforcement, any judicial processes you might be involved in, our education system, things like family law or the contract or tort or property disputes that we might someday be involved in. Most of this is conducted by the states. So by placing the limitations of the Bill of Rights on what the kinds of things that the state could do, we had this dramatic shift in the power between individuals and the states. But it wasn't always clear that the 14th Amendment would serve as the vehicle that incorporated the Bill of Rights to apply to the states. And in fact, before we had the passage of the 14th Amendment, that was not the situation at all. So we start this discussion, as we have started so many of our discussions about constitutional law issues, with an opinion by Chief Justice Marshall. And this is the Barron versus Baltimore case. This was a case from 1833, so it's before the Civil War, before we had the passage of the Civil War amendments. And this case involves some individuals who claim that the city of Baltimore ruined their wharf by diverting some streams and thus making the water around their wharf too shallow for boats to be able to use it. So they sue the city for taking their property without just compensation in violation of the Fifth Amendment. And so their argument was that the Fifth Amendment says here that no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So the plaintiffs here are saying, I've had my private property taken for public use without getting my just compensation. I have a Fifth Amendment, a violation of my Fifth Amendment rights here. But Chief Justice Marshall, in this opinion, and this was actually one of his last opinions, he died about 2 years after he decided this case, he says that the Fifth Amendment doesn't apply to states or to local governments like cities. He tells us this is a case of great importance, but not much difficulty. Aren't they all to him? He seems to always tell us. But he tells us that the purpose of the Constitution was to create this national government. And the purpose of the Constitution and the Bill of Rights was to restrict national government, not state governments. And you might notice the sort of change in perspective that we have today versus what we had at the time this case was decided. Today, again, as I said, I think most of us would view the Bill of Rights as a guarantee that we have of our liberties as individuals, a statement of our rights that we possess. But Justice Marshall looks at the Bill of Rights and he doesn't see this guarantee of basic liberties. He says this is just a limitation on the things that the federal government, but not necessarily state or local governments, can do. So because the rights that are protected by the Bill of Rights didn't apply to the states before the Civil War, that meant that states could and did violate all of these rights that we consider now to be so fundamental within their state. They violated free speech rights, they established state religions, we had states that had established state churches. Massachusetts, for example, had a law that required every man to belong to a church. There were state laws that prohibited people of certain religions from serving on jurors or from acting as witnesses in state judicial proceeding. A number of states, as I said, that had their established churches that allowed them to basically give taxpayer money directly to ministers. We frequently had states that banned newspapers and books. There was just generally very little protection of individual civil rights until we got to the Civil War. And after we had the passage of the Reconstruction Amendments, we then had these questions about what exactly did they mean? What effect did they have on this relationship between individual rights and state and local government? So those questions quite quickly found their way to no other than the United States Supreme Court. The key early case interpreting the Reconstruction Amendments and what they meant in terms of what restrictions they placed on the states came in the slaughterhouse cases from 1873. So these cases were decided about less than 10 years after the end of the Civil War, and it was a 5-4 decision, so we had a closely divided Supreme Court. And the facts of this case involved the state of Louisiana, which gave one company a 25-year monopoly of all slaughterhouses for the city of New Orleans. So everybody who wanted to slaughter animals had to use this one company, and they had to do so for a fixed fee. So the cases that made their way to the court involved a group of butchers who say that this monopoly on the slaughterhouse industry interfered with their freedoms to practice their trade. And they brought their claims under several arguments that were all based in what were at the time these brand new amendments, primarily the 13th Amendment and a number of different provisions in the 14th Amendment. Now, we have the state here, of course, arguing that this law fell easily under their police powers, that this was a law designed to protect the health and safety of the citizens of the state. They said that slaughtering is a noxious business, and they had reason to want to consolidate it, make sure it was only sort of in one part of town and being done in a more uniform way. So the claim that these brand new amendments would give these individual butchers the right to say that the state couldn't exercise its police powers in a way that it could have easily before these amendments was really a big deal. So I want to go through each of the butchers' arguments here under different provisions in the 13th and 14th Amendment, and talk a little bit about what they were arguing, what the court decided then, and then what the status of this interpretation of these amendments is today. So first, the butchers made a claim that was based on the 13th Amendment. The 13th Amendment, which tells us that neither slavery nor involuntary servitude shall exist within the United States. So, and the butchers argued that the monopoly here forced them into a kind of involuntary servitude. They were being forced to work in stockyards that were owned by monopoly. They were being charged monopoly prices, that this all fell under the 13th Amendment, and they had a constitutional right against this law. But the court took a look at the 13th Amendment, and it said that the 13th Amendment requires some kind of forced labor or slavery. They said that we needed to view the 13th Amendment through the vantage point that it was a result of the Civil War and the concept of slavery as was fought in the Civil War. And they rejected sort of the broader interpretation that there was a claim of involuntary servitude that would include a claim like what the butchers were making here. So the Court in the Slaughterhouse Cases in 1873 told us that the obvious purpose of the 13th Amendment was to forbid all shades and conditions of African slavery, not to stop butchers from having to work in a particular slaughterhouse. Now, as we already talked about when we talked about Congress's powers under the 13th Amendment, this interpretation of what the 13th Amendment is protecting was later overruled. It was overruled in a 1968 case called Jones versus Mayer Company. It was a challenge to the Fair Housing Act. That case involved a Black couple who tried to buy a home. The owner refused to sell them the home because of their race. And in 1968 and continuing today, the court said that Congress has the power under the 13th Amendment rationally to determine what are the badges and incidents of slavery and the authority to translate that determination into effective legislation. As we've pointed out, this also includes the ability to enforce protections from slavery and involuntary servitude, even against private conduct. So the court's view of what the 13th Amendment was protecting in the slaughterhouse cases did not stand the test of time. The butchers then made a number of arguments that were based on provisions that were found in the 14th Amendment, and the court considered these. I want to come back to the Privileges and Immunities Clause, which is addressed earlier in this case, and start by taking a look at the Due Process Clause. So the 14th Amendment tells us that no state shall deny any person of life, liberty, or property without due process of law. The butchers argued again that because they had been prevented from exercising their trade, that they have had a violation of their rights under the Due Process Clause of the 14th Amendment. Once again, the court did not buy this argument. The court found that restraint of trade is not a deprivation of property under this clause of the 14th Amendment. And in fact, the court told us that under no construction can the restraint by the state of Louisiana upon the exercise of their trade by the butchers of New Orleans be held to be a deprivation of property within the meaning of that provision. So this approach to thinking about what it is that the Due Process Clause in the 14th Amendment protects has also not stood the test of time, and it has been overruled. In the late 19th and early 20th century, we had the court protect the right to practice one's profession as a right that is protected in the Due Process Clause. But primarily what we've seen is an expansion of the meaning of the Due Process Clause and an understanding of the Due Process Clause that includes things like the right to privacy and rights of autonomy, which we'll be talking about in the rest of our due process discussion. So then the butchers turn to another part of the 14th Amendment that tells us that no state shall deny to any person within its jurisdiction the equal protection of the laws. Again, the court was not persuaded here. They said that the Equal Protection Clause was about protecting African Americans and formerly enslaved people, that the Equal Protection Clause was included in the 14th Amendment as a way to try to prohibit the Black codes, the laws that were being passed that were putting up obstacles for formerly enslaved people and their descendants to be able to fully participate in all aspects of life. And so the court, again, told us that we doubt very much whether any action of a state not directed by way of discrimination against the Negroes as a class or on account of their race will ever be held to come within the purview of this provision. Well, that was pretty wrong. We now actually have a quite broad interpretation of the Equal Protection Clause, and the court has recognized the use of the Equal Protection Clause as a means to prevent all types of discrimination from the government, including protections of all different types of classifications of people. So then we can return to the butcher's argument to say that they had rights that were violated that are protected by the 14th Amendment's protection of privileges or immunities. The 14th Amendment tells us that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So the court was tasked with this question of telling us what this meant. What does it mean to say that states can't abridge our privileges or immunities as citizens of the United States? What all were they protecting here? And the court, in what I think is a pretty confusing decision, tells us that their interpretation of the privileges or immunities is a very narrow definition of what these privileges are or immunities are. Privileges or immunities, they tell us, refers to those rights that owe their existence to the federal government. So the court makes this distinction between what it means to be a citizen of a state versus being a citizen of the United States. And says what this protects is the rights that you have as a United States citizens, but not for any additional kinds of rights. The court said that any other interpretation of the Privileges or Immunities Clause would just bring about too big of a change in the relationship between the states and the federal governments, who, of course, remember, have the power under Section 5 of the 14th Amendment to enforce violations of the rights that are in the 14th Amendment, but also between the states and the people of the states. And the court here just doesn't think that that was what the 14th Amendment was meant to do. It was not meant to give the federal government the power to assure that the states were protecting these individual liberties. It was not meant to give federal courts the power to sit in judgment of laws that the state passes or things that the states might do. The court here says, such a construction would constitute this court a perpetual censor upon all legislation of the states on the civil rights of their own citizens. It radically changes the whole theory of the relations of the state and federal governments to each other and of both these governments to the people. We are convinced that no such results were intended by the Congress which proposed these amendments, nor by the legislatures of the states which ratify them. So, do we know what the Congress that ratified these amendments might have thought about what kinds of protections they were giving to individuals when they included the protection of privileges or immunities as against the states? Well, we can't really know for sure. On the one hand, we have some evidence, like this statement from Senator Jacob Howard. He was the senator from Michigan, a major figure in the drafting of the 14th Amendment. And during the debate in the Senate over the proposed 14th Amendment, he noted that it was the great object of the amendment is to restrain the power of the states and compel them at all times to respect the great fundamental guarantees of the Article 4 Privileges and Immunities Clause, which applies to the federal government, and the Bill of Rights. Other historians, however, say that Congress would have never allowed such an imposition on state sovereignty. Now, the Supreme Court could have just written an opinion that says the right to exercise one's trade is not a privilege or immunity that is protected by the 14th Amendment, but the court didn't do that. It went further than that to say that the Privileges or Immunities Clause is actually very narrow in what it protects, and that there's very little that is actually protected under it. They explained to us that there is a difference between the privileges and immunities belonging to a citizen of the United States as such, and those belonging to the citizen of the state as such. The latter must rest for their security and protection where they have heretofore rested, for they are not embraced by this paragraph of the amendment. So they do mention a few different things that they say are these rights that come that are part of our privileges and immunities as being citizens of the United States. It's on the second paragraph of page 546. They talk about the guarantees that you can come to the seat of government to assert any claim that you have might against the government, transact any business you may have with it, seek to its protection, to share its offices, the right of free access to the seaports, operations of foreign commerce. So they list off a couple of these things here, although every single one of the privileges or immunities that they mention were protected already, even before the passage of the 14th Amendment. So their narrow interpretation of the Privileges or Immunities Clause in the 14th Amendment really kind of in essence made that provision in the 14th Amendment a nullity. And this is something that the dissent points out. Writing in the dissent, Justice Field says that the majority's definition of privileges or immunities virtually reads it out of the Constitution. He says, the amendment does not attempt to confer any new privileges or immunities upon citizens or to enumerate or define those already existing. It assumes there are such privileges and immunities which belong of right to citizens as such, and ordains that they shall not be abridged by state legislation. Under the majority's view, Justice Field wrote, the Privileges or Immunities Clause was a vain and idle enactment which accomplished nothing and most unnecessarily excited Congress and the people on its passage. So, looking back then at where we were and where we are now on this question of the meaning of the Privileges or Immunities Clause, As we've just been saying, in 1873, the court adopted this narrow, very narrow interpretation of what it protected, which was that it protected things that were already protected before the passage of the 14th Amendment, and changed virtually nothing in terms of the relationship between individuals and state and local governments. And unlike the other parts of the slaughterhouse cases, today this is still good law. From 1873, when this case was decided, until 1999, 126 years later, there was only one case that used the Privileges or Immunities Clause of the 14th Amendment to invalidate a law. And then a mere 5 years later, that decision was overruled. There was one case in 1999 where the court relied on an argument that a privilege or immunity in the 14th Amendment had been violated. It did not, however, seek to overturn the slaughterhouse cases, but rather said that the right that was protected, that was violated here, was the right by the state, was the right to travel, which is one of the rights that we have as citizens of the United States. So this leaves us with this continuing question of whether or not the Bill of Rights in the Constitution applies to the states. We started from a place of thinking that perhaps the Fifth Amendment due process clause might be an application of a guarantee of rights that would apply to state governments. But Chief Justice Marshall, writing in the Barron versus Baltimore case, said no, that only applies, that's only a limitation on the federal government. And then we have the slaughterhouse cases entertaining this question about whether or not the 14th Amendment, we're now 5 years after the ratification of the 14th Amendment, whether its protections for the privileges or immunities of citizens might be a means of enforcing individual liberties against the states. And as we said, many have argued that this is what the framers of the amendment intended, as we saw in that quote from Senator Howard. So the Supreme Court in the slaughterhouse cases shuts down this argument as well, again, as I said, by a 5-4 vote. So this meant that for quite some time, and going into the 20th century, the court continued to follow the Barron approach and hold that states do not have to follow the Bill of Rights. This meant that up until the early 20th century, states could do things like search your home without a warrant. They could require you to join a church. They could try you for a crime without a jury. They could try you twice for the same crime. They could inflict upon you cruel and unusual punishments. But when we get to the early 20th century, the Supreme Court started to consider some alternative ways to think about this question of the Bill of Rights applying to the states. And we saw the justices start to look at a different part of the 14th Amendment, which is the 14th Amendment's protection for due process, that you can't be deprived of life, liberty, or property without due process of law. And we saw the court in some early 20th century cases start to tell us that there are certain rights that are so fundamental that they are an essential part of due process. So these fundamental rights, as the court is telling us exist, aren't protected because they are mentioned in the Bill of Rights. It's not a protection of the Bill of Rights that's against the states, but they are protected because they are an essential part of due process of law. And so for a state to deny one of these rights, it could amount to a denial of due process under the 14th Amendment. Now, in this first case where we saw the court introduce this idea of fundamental rights, the Twining case, which I did not have you read, it was considering the right not against self-incrimination. And they concluded there that this was not one of these rights that was so essential to due process. But nonetheless, they introduced this idea that some rights are what they called fundamental rights, and that they are fundamental part of liberty and justice, which inheres in the very idea of free government and is in an inalienable right of a citizen of such government. So the court started to slowly consider what kinds of rights are these fundamental rights that are protected by the Due Process Clause. And they started by considering primarily criminal rights. For example, things like the denial, if a state were to deny a criminal defendant a public trial, that they said would be a problem, not because the right is found in the Sixth Amendment, but because this right is fundamental and you simply would not have due process without it. But then we started to see the court consider not just rights related to criminal charges, but other rights that it deemed to be essential to our liberty that is protected by the Due Process Clause. So we saw the court start to slowly apply various provisions that are found in the Bill of Rights to the states. 1925, for example, in the Gitlow case, the court held that the First Amendment protection for freedom of speech is one of these essential rights, these fundamental rights, these essential liberties that is protected by the Due Process Clause. In 1934, the court first said that the state may not deny counsel in capital cases. In 1940, we had the court first hold that the First Amendment's religion clauses, the Free Exercise Clause and the Establishment Clause, apply to the states. And this started to raise the question, what exactly is happening here? If we're saying this particular right that's found in the Bill of Rights applies to the states and this other particular right that's found in the Bill of Rights applies to the states, then what else? What other parts of the Bill of Rights, or just what other rights are there that are fundamental and essential parts of our liberties? By the mid-1940s, a major debate has developed among legal scholars, but more importantly, among Supreme Court justices. What rights are incorporated, as they say, incorporated through the Due Process Clause to apply to the states, and what rights are not? And most importantly, is it the entire Bill of Rights that applies to the states, or are just some of these rights fundamental rights? So this debate primarily featured Justices Frankfurter, Cardozo, Harlan on one side, which was known as the selective incorporation side, that it's not just the entire Bill of Rights, there are just some of these rights that are fundamental rights, and we need to identify those. And then on the other side, we had Justices Black and Douglas, who were total incorporationists, who argued that the entire Bill of Rights can and does apply to the states. So the selective incorporationist told us that it's not everything that applies to the states, but rather it's only these rights that go to the very essence of a scheme of ordered liberty that are incorporated to apply to the states. They also talked about what we're trying to identify are a principle of justice so rooted in the traditions and conscience of our people as to be ranked as fundamental. They also talked about how denials of these rights, these fundamental rights, would offend the canons of decency and fairness. They also expressed a number of concerns about federalism, that if we took the total incorporationist approach, that would be too much of an infringement on state sovereignty, that recognizing and respecting the rights of states would requires the court to proceed more cautiously and just identify those rights which it considers to be at the very essence of a scheme of ordered liberty that were fundamental and part of the canons of decency and fairness. But meanwhile, we had the total incorporationists who were saying that all of the Bill of Rights should be recognized as applying to the states. They argued that this was the purpose behind the 14th Amendment, to place these kinds of limitations on the states. And these justices had concerns about the judicial discretion that would come through that arises through a selective incorporationist approach, that the court would be able to just pick and choose which rights it thought were so fundamental that it could incorporate them to apply to the states. And the court, this side of the argument, rejected this argument about respecting a federalism. They said federalism doesn't mean that states just get to experiment with rights that are so important, like the Bill of Rights. So this debate was a long one, and it attracted a great deal of attention, particularly from legal scholars, because we see the justices here making arguments that are based on the questions that we have been asking throughout this entire semester. Questions about the appropriate role of the court in making these kinds of significant decisions, about issues of federalism, what it requires, what the justices should do to preserve it and or respect it, and about issues of constitutional interpretation and what is the appropriate methodology for interpreting the Constitution, as they were attempting to do in this case. So we have this big debate, and the question then becomes, who won? And in one sense, the selective incorporationists won. Justice Frankfurter won, because the court never did hold that the entire Bill of Rights automatically is protected from the state government. The court has always and continues to adhere to a position of selective incorporation. But there's another sense in which the total incorporationists have won, in which Justice Black has won. And that is because virtually every one of the Bill of Rights has been incorporated to apply to the states. Almost all of the earlier decisions that the court had decided where they refused to incorporate certain provisions in the Bill of Rights have been overruled. This was one of the most dramatic effects of the Warren Court, is that we saw the justices move towards almost complete incorporation. And so we have hit a point where the application of the Bill of Rights is almost entirely complete. Now, all of the rights that are found in the Bill of Rights do apply to the states, except the Third Amendment's protection against not having to have soldiers quartered in a person's home. This is almost certainly in part because there simply just are almost never Third Amendment cases anymore. I don't believe the Supreme Court has ever decided a Third Amendment case. There actually was one from the Second Circuit back in the 1980s and involved some New York corrections officers who were on strike, and they were kicked out of their employee housing by National Guardsmen who had been called in to take their place, and they brought a Third Amendment claim and won a Third Amendment claim. But for the most part, we just don't have Third Amendment arguments that the court has at least decided for us. The Fifth Amendment right to have a grand jury indictment in a criminal case has yet to be incorporated to apply to the states, as has not the Seventh Amendment right to have a jury trial in a civil case. Until relatively recently, I had a couple of more rights that were on this very, very short list of provisions in the Bill of Rights that have not been found to apply to the states. But I've had to take those off of my list. Those were the Eighth Amendment's prohibition against excessive fines, and the Second Amendment's right to bear arms. The Eighth Amendment prohibition on excessive fines, the court found applies to the states just last year in 2019. And the Second Amendment's right to bear arms, the court incorporated to apply to the states in the 2010 case of McDonald versus City of Chicago. This was a case the court heard 2 years after it decided the Heller decision. So through this process, not only does now almost all of the Bill of Rights apply to the states, but it also led to a jurisprudence in which due process has a very broad and important role as the protector of what we call fundamental rights. And we have these two protections for due process in the Constitution. We have the Fifth Amendment protection, which we had prior to the Civil War, and this protects us from the federal government violating our due process rights. And then we have the 14th Amendment's protections against infringement of due process by state and local government. So that is the story about how the Bill of Rights came to be applied to the state and local governments. In our next lecture, we will talk a little bit more about this evolving understanding of what due process means and start by taking a quick look at the concept of procedural due process. I will see you then.